Welcome to Cordell Cordell's Men's Divorce Podcast, bringing you information for guys before, during, and after divorce, and everything related to family law. This podcast is not to be taken as legal advice, and no attorney-client relationship is established.
Hello, and welcome to another version of Men's Divorce Podcast. Today, we will be discussing premarital assets and how to protect those premarital assets. My name is Kelly Burris. I'm a senior litigation partner in the Austin, Texas office. And I have today with me Ryan Phillips, who's our senior litigation attorney, one of our senior litigation attorneys from South Carolina. Ryan, welcome.
Hey, Kelly. Thanks for having me on today. Like Kelly said, I'm a senior litigation attorney in the Charleston, South Carolina office. This is my 15th year practicing law overall and my 6th year with Cordell Cordell, and I'm happy to be here.
You know, as we always kind of say, we like to do these to give you an idea and to give people an idea of what some of the law is, but make sure that if you need something specific to your case, that you schedule a consultation with an attorney. You can schedule a consultation with our firm at 1-866-DADS-LAW or go to CordellCordell.com, CordellCordell.com. All right, well, let's just jump right into it and talk a little bit about how to protect premarital assets. I mean, I think, Ryan, that you know, most people think when they think, oh, I've got premarital assets, what do I need to do? They immediately think premarital agreement.
Yeah, I think you're right. And this is a topic that's been on my mind a lot lately because I've this year, I've had two full trials that were multiple days that focused primarily on this issue. And I'm right now getting ready for another trial that primarily focuses on this issue that's supposed to start on Wednesday. You're right. I think that one of the issues is that people don't really think about this usually until it's too late. And that obviously is a problem. Like you said, premarital or prenuptial agreements are usually going to be the best choice to preserve and to protect premarital assets. One of the issues with that is that they have to, by their very nature, be done before you get married. It's in the name. It's an awkward topic to bring up with a potential spouse. But it's usually going to be the best choice if you really want something that's a very strong gatekeeper for protecting premarital assets. The most important thing with a premarital or prenuptial agreement is going to be, of course, contacting an attorney is always going to be the top advice. A Cordell attorney, of course, would be a good choice for that. But you've got to make sure to meticulously follow all the state statutory requirements in your particular state for it to be effective. I'm only licensed in South Carolina, but for example, here, I'd want to make sure that both parties have independent legal counsel. And I would say in any jurisdiction, even if it's not required, with both parties having separate independent legal counsel is really going to give you a boost if the other party ends up challenging your agreement in the future. It's really going to make a judge, in my opinion, lean more towards enforcing the agreement, which is what you want. Both parties are going to need full financial disclosure. You're going to want something that's attached to the agreement that defines how these things are going to be divided, but also what are these things. And it can't be just something like my bank accounts. It needs to say, my Wells Fargo account ending in 1234, my Bank of America credit card, my E-Trade investment account, my IRA, my 401k from XYZ Corporation. It needs to be specific and it needs to be clear. Another really important requirement is going to be for both parties to have enough time to review the document before the marriage actually takes place. A judge is going to want to make sure that nobody was coerced or felt that they were under undue pressure or duress when they signed the agreement. You can't basically shove an agreement under somebody's nose 15 minutes a day, 2 days before the marriage and basically tell them, you signed this agreement or we're not getting married. That's going to be a problem for a judge in the future. So really, a premarital agreement is always going to be the top choice. There's never a guarantee that it's going to be enforced by a judge moving forward in the future, But as long as you follow all your state's particular statutory requirements, you're going to have a much higher likelihood of success doing that in the future if it does become an issue.
Yeah, and I think another thing with respect to premarital agreements that a lot of people don't think about is that it also helps with estate planning. It's so I always tell my clients if they're having a hard time selling a prenup on the divorce aspect, sell it on the estate planning aspect and throw both of them in there with the agreement, because it really does help protect assets. And even if parties don't have a ton of premarital assets, it's certainly a good idea to have something like that so you both parties know what they're going to the marriage with, and you're protecting both assets prior to marriage and then assets that you might earn during the marriage, because I think premarital agreements can not only protect premarital, but it can also change marital property into separate property too, right?
Yeah, I think you're right about that. The estate planning aspect is a really good point. And to your point about circumstances changing in the future, that's also something that can be in the back of your mind during the marriage. Your financial condition on the day you get married is often much different than it is in the future upon a potential divorce, especially if it's both of your first marriages and you've been married 10, 15, 20 years at the time of divorce. You're most likely going to be in a very different financial condition. And a premarital agreement that may have been what a judge would consider fair and equitable 15 years ago, when both of you were first starting out in the workforce, you were young, you didn't have any children, you had very little assets, that may be a very different situation than in the future. 15 or 20 minutes later, a judge may not think that it's so fair anymore, especially if it's something like denying a spouse alimony, dividing property in a specific way that the outcome in the future would be inequitable. So it's a good idea maybe to, throughout the marriage, to consider whether the future audience, i.e. a judge, may consider it to be equitable still. And there may be a situation where you want to go back to the drawing board and amend the document. Again, just like creating the initial premarital agreement, it's not the easiest conversation to have with your husband or wife, but at this point, the awkwardness, I think, is overcome by the importance and the financial aspect of it in the future.
So let's talk about what happens when you get married without that prenup, like most people do, and protecting those assets. And so we talked about premarital agreements, and you kind of, I think, got into partition and postnuptial agreements to some extent. And say parties aren't ready to get a divorce, or they're not wanting to get a divorce, but they're still wanting to protect their assets. You can always enter into a partition, what we call a partition agreement in Texas, or a postnup, which the laws are similar in most states with respect to both of those documents, but it certainly can then, protect assets that are acquired during the marriage, or if somebody inherits something that was maybe unexpected, that can also help make things easier in the event of death or divorce.
Yeah, I think you're right about that. In South Carolina, we would call them postnuptial or agreements. And I think that does go back to there's an estate planning aspect, like you said before, and this is another way that you can sort of compensate or address changed circumstances that happen during the marriage. Making more money, unexpectedly coming into additional assets or things like that. In South Carolina, at least, there's an exception in the law to inheritances. So the general rule here, at least, is that any property or assets that either party acquires during the marriage, meaning from the date that your marriage actually becomes official, up until the date that somebody files something to start a family court action, anything within that window is going to be presumed by law to be marital property and subject to division between the parties. It doesn't have to be 50-50 in this state, but most likely it's going to be 50-50 if it's acquired during the marriage. Now, an inheritance is an exception to that. A party that obtains an inheritance during the marriage is still going to be presumed to be non-marital rather than marital. The problem ends up coming up when people commingle those assets, which is probably a natural thing for people to do when you're in a marriage. It's a partnership, right? You might have joint bank accounts, and you may get a $50,000 inheritance from Aunt Susie who unexpectedly passed away, and you just put it into a joint checking account because that's what you and your wife use to pay the bills. And then eventually, when a divorce comes, you find that that inheritance has been so commingled with your other marital assets that it becomes untraceable. And at that point, you've pretty much lost that the built-in legal protection of it being a non-marital asset. And you're going to have a really, really hard time and a massive uphill battle to convince a judge at that point, if it still even exists, to try to carve out that $50,000 from the rest of the marital estate because you didn't keep it separate. And that's the number one piece of advice that I can give to anybody. If you don't have a premarital agreement, fine, we can work with that. During the marriage, though, don't commingle assets. That is just the number one piece of advice that I can give to people. You might commingle earnings that you have during the marriage, like your regular paycheck or however you earn an income, but an inheritance, things like that, always keep it separate. Commingling is the number one problem that I see in almost all my cases where transmutation, as we call it in this state, is an issue.
Yeah, and we have a similar issue. I mean, and commingling doesn't necessarily have to mean that you put it in an account with your spouse's name on it. So in Texas, if you put in an account, that inheritance in an account solely in your name, and then you put income on top of it or new money coming in and you don't keep that inheritance totally separate. Or if you have, say, a money market account where you're investing and you're getting interest and dividends, and I know state law differs depending on the state, but like in Texas, interest and dividends can be considered community. And now you go at a 15, 20-year period where you can't get those statements. And if you can't figure out how much of that account is community, how much of it is separate, and you don't have the statements, even if it's in your sole name, that whole thing can be considered community and subject to the division of the court, like subject to division. It's community, and can be divided upon marriage. Another issue like we have in Texas, if you do put separate property into an account or in your spouse's name, even if it's jointly with your name, the court in Texas presumes that you gifted it. So even if it's, I had a friend whose spouse had a sole property residence and gifted it to his spouse. And the entire thing ended up being spouse's separate property, even though it was his separate property originally. So you have to really be careful, I think, about how you're titling. And by titling, I mean whose name you're putting it in. Not necessarily real estate, but any asset. You have to really be careful how you're going to title that asset and what kind of accounts you're putting it in and whose name you're putting on the account. But sometimes it doesn't even matter whose name it's on. It just matters whether or not what kind of money's going in there and whether or not you can trace it. Do you run into similar issues in South Carolina as far as gifting and those kinds of concerns?
Yeah, we do. And you raise a good point with it not necessarily being the most important thing with how it's officially titled. Although that is important. For example, what comes up very often, especially here in South Carolina, and I imagine for the same reasons, probably in places like Texas, where there's a lot of rural communities and families that have been in those rural communities for quite a bit of time, and they've got pieces of property like real estate, land, whether it's a farm or just property that they own, residences, etc., that have been passed down throughout the family. And you never want to commingle the title on those assets. But the problem ends up being in those cases that you start to use that property in support of the marriage. And that's what gets people in trouble as well. You want to always keep that kind of stuff separate too. That's one of the big issues that you see in areas like this.
Yeah, I mean, those are all good tips. Are there any other pitfalls or things that you notice people do frequently that would be a good tip on how to keep assets from transmutating?
Yeah, I think that a lot of times it's more about what not to do rather than what to do. What to do, again, going back for the fourth or fifth time, is to use a prenuptial agreement if you can. But in this state, really what the court ends up looking at, and I think it's similar in a lot of other states too, the court, at the end of the day, they're looking at the intent of the parties. And here, it's really, they're supposed to be looking at the intent of both parties. Did both parties, by their actions and whatever other evidence is produced at trial, did those parties intend to treat the disputed property as a joint property of the parties during the marriage? That's really, when you really distill down the law here, that's what a judge is looking for. And it's almost never a huge smoking gun. The one thing that might be a smoking gun is if you have, for example, a premarital home, and then you put your spouse's name on the title a year after you get married or whatever, that's probably going to be transmuted. But in the absence of something like that, really what we're looking at trial, and like I said a few minutes ago, I've tried 2 of these cases on these issues already this year. I mean, plenty in past years, but 2 already this year, and 1 probably starting on Wednesday this week. They're looking at all these little things that maybe add up over time. They're looking at things like, what money did you use to make improvements on the property? Did you use joint assets of the marriage to, add a deck onto your house? Did you use joint assets of the marriage to improve the structure of the building, add a new roof and things like that? Now, I get it. I mean, some of those things are unavoidable. Our new roof, for example, is just part of regular maintenance of the house. But if you can somehow sort of partition out the money that you use to do that, it can be very, very helpful for you. You just don't want it to be seen by a judge as using that property as the joint property of the parties during the marriage. And things like just living in the house, here at least, that's not enough. I mean, one of the cases that I tried earlier this year, the parties had lived in the house that my client owned before the marriage. They lived in that house for 15 or 16 years by the time the case was filed. My client had only owned it for, 5 or 6 months before they got married. So it wasn't like some property that was passed down through the generations of his family. But what the other party relied on primarily was how long they had lived in this house together and raised a child to a teenager in this house. But he never put her on the deed. She was never on the mortgage, the original mortgage, for obvious reasons, but she was never added when he refinanced the mortgage 8 or 9 years into the marriage. She was never added onto any of the other documentation that would go to show the ownership of this house. And that was something that the judge found really compelling in that case. So really, it's more, like I said, it's about what not to do versus what to do if you don't have a prenup.
Right. And I think it's really important, again, to mention that, every state is different. So we don't call it transmutation. We call it characterization, whether something is a separate property character, community character, because we're a community property state. And, it's not so much, the intent as it is, unless it's gifting, unless somebody's making a claim that the other party gifted them. We don't really look at intent much. It's more, we have reimbursement claims. So, if that property that you mentioned was never titled in the in the name of the other property, the other person, and it was refinanced using solely that one person, it never got put into spouse's name, then the only claim spouse might have really would be for what we call a reimbursement claim, to say, hey, the community paid down X amount of dollars on this separate property asset. And so the community is entitled to a dollar for dollar reimbursement of what that party paid. Other states, they get a percentage. Other states, like you mentioned, intent. So I think it's really, really important, to make sure that you talk to an attorney and make sure that you have an understanding of how things are characterized or maintained in your particular state. But I think a lot of these tips are good regardless, trying to, whatever your state law is, making sure that you're really cautious about keeping things titled in the correct person's name, and that you're tracing out and keeping documents and things like that is really helpful. And now, do you guys do a lot of tracing where you have to have documents and you have to have, so ours is clear and convincing evidence. So we have to have all the documents to trace a piece of property back, unless we can, unless it's not been commingled, or unless that there's some other issue. But for the most part, especially accounts, we have to have all of the documents. That means if it's a 10, 15-year-old separate property account, we may need every statement from that 10 to 15 years.
Yeah, it's pretty similar here. I would say you don't need every single statement. At least in my experience, I've never really had to do that. But the typical way that I would handle this, and this comes up a lot with like retirement accounts, 401ks, and things like that predate the marriage. So what we'll typically look at is getting an account statement from the date of filing. So with that, you can at least lock in what existed on the date of filing before. There's $50,000, for example, in this IRA or 401k or whatever. Well, if you have a statement on the date of filing, you're pretty much already there. You can show very definitively with that one statement that there was $50,000 the person earned before the marriage that was in the account already on the date that they were married. And you get another statement as of the date of filing, and you look at the difference, and because you're also going to be entitled to the earnings on the non-marital portion as also retaining their non-marital character. Sometimes people forget about that and they shortchange themselves. So you need to be able to show that too. But when it gets a little more complicated is when there might have been more than one premarital job and money has been rolled over to different 401ks and other accounts. In that case, you're going to need a lot more statements than just one. You're going to want to be able to show, like you said, the money sort of from its original source, how it went from job 1 to job 2 to job 3, and a 401k continues to roll over. And that's the same with other types of accounts too, like a savings account maybe. Those are usually easier to trace because there's generally, unless you just decide to change what bank you use, there's not a whole lot of turnover or rollover in those accounts. And I mean, really, what it comes down to a lot of the time is just making the other side prove their case, because here, at least with transmutation, if it's presumptively non-marital, meaning I can show that the $50,000 or the house or the boat or whatever existed before the marriage, if the other side is saying that it's marital property, our law says the burden is on them to prove that it is marital now, not on you to prove that it is not. And it's a really important distinction, I think, that a lot of people forget about, attorneys included. In at least one of those two trials from this year that I was talking about, the other attorney clearly did not really think through how they were going to prove their case. I think they essentially just thought the trial was going to be about the way the judge felt that day, rather than actually sticking to the rules of evidence, sticking to the case law and the statutes in South Carolina, which is what I focused on, just the letter of the law. And I don't think it was a very hard decision for the judge. A lot of people, for whatever reason, just kind of roll over on this issue. And it's actually not incredibly difficult to be able to carve out the money or the value or whatever it is that's non-marital. You've got to do some extra work, but that's what we're getting paid to do as attorneys, and that's just part of the job. And you should be doing the job if you want to do it properly.
Yeah, and I again, the state by state stuff always amazes me because we do have to have all of those statements potentially. So it really is, I always tell people they come in and they've got an account from 15 years ago. And it's like, well, do you have these statements? I think I have a lot of initial consultations that'll come in and they'll go, well, I had, $80,000 sitting in this retirement account that when we got married 15 years ago, so I should just get that back out, right? And it's like, no, I mean, well, I didn't move it and it's still in the same account, or, it was, she knows or he knows that $80,000 was in existence at the time. And that
the he or she knows thing is not going to hold up in court. You're right about that. I will say that in those situations, I think that it may be, at least here, beneficial to have multiple account statements or every account statement, which is what it sounds like you're talking about in Texas. I will tell my clients to give me all those statements, but usually what I end up actually using in court, if it becomes an issue, is probably going to be much less than, 12 times however many years that the accounts existed for statements.
Yeah. And for us, it's not hopeless if you can't get those statements, but it is important to know that, if you're listening to this, go get those statements and get that information and hold on to it and make sure you have it. Even if you're not contemplating divorce anytime soon, having that information can be the difference between being able to protect that asset and not being able to protect that asset. So,
and it adds up to a lot of money very quickly.
Yeah, it does. It can add up to a lot of money. And just on a note, I think you had said the burden of proof sometimes can shift to the other side. Again, in Texas, it's the burden of the person trying to prove separate property. They have to prove it by clear and convincing evidence, no matter whose name it's in. So again, that's why it's really, really important to to consult an attorney from your state. Make sure that you're aware of the law, and that's about all we have time for today, Ryan. So thank you again so much for joining us. And it's a really interesting topic, and there's a lot of information that people need to be aware of.
Yeah, thanks, Kelly. I appreciate you having me. It is an interesting topic, and it's very, very important, and it's one that people often overlook, but it is a very, very, very important topic.
Thanks again. And as we mentioned at the beginning, and as I've been kind of mentioning, if you need more advice about this topic or any kind of family law matter and would like to schedule an initial consultation, call 1-866-DADS-LAW to schedule, or you can visit our website at CordellCordell.com. I hope this was helpful to everyone, and we'll see you on next time on Men's Divorce Podcast.